Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss guidelines given in the case of euthanasia. We all know Article 21 gives the right to life and liberty. The state should protect the life and personal liberty of each and every individual. Life is an important thing in the eye of the state or also the law. But sometimes it will be inevitable to take away the life in cases of permanent vegetation, like Aruna Shanbag case 2015, where a hospital nurse, she was ravished by the hospital staff by tying her to a cot. Ultimately, she went into coma. She was there in coma for about 20 years. Ultimately, even though the passive euthanasia was granted to her, but she died in the meanwhile. Very pathetic case. In that connection, the NGO Common Cause, they have been fighting for the so-called aspect of euthanasia. This case is also relating to Common Cause versus Union of India, which filed a miscellaneous application in 2019. It was numbered as 1699 by 2019 in WP number 215 by 2005, and ultimately the guidelines were given in this case on 24th January 2023 by 5 judges bench, that is Constitutional Bench, consisting of Justice K.M. Joseph, Ajay Rastogi, Anirudh Bose, C.T. Ravikumar and Rishikesh Rai. So it has the Honorable Supreme Court of India modified the previous directions regarding euthanasia or mercy killing. So actually the judgment previously was issued in the year 2018. Actually this is a modification. Right? So let us straight away go into the directions. So previously, first point is actually on the application filed by Indian Society of Critical Care Medicine. They have actually requested the court to give a clarification regarding advance medical directive. So you all know what is a will. So before dying, a person wants to bequeath his property in the name of his beloved ones. Likewise, advance medical directive is, suppose I am suffering from some terminal disease. If I die, what? So whether my organ donation, straight away, organ donation can be done or not. Where should I be laid? All these things will be given as a directive. This is advance medical directive. It is a legal document. Please remember, of course, this previous direction, it has to be certified or attested by 2 witnesses, and the judicial magistrate first class, he has to be informed. Then only his last rights will be accepted. But now, please remember, present guidelines are so they need the witnesses. One of the witnesses can be a legal guardian. So consent of the nominee itself is sufficient. In place of judicial magistrate, if it is attested by a notary, if this advance medical directive is attested by a notary public, it is itself is sufficient. That means you need not go to the magistrate. Right? In place of judge, it can be notarized. Okay. Second, as regards the death or euthanasia, the family members actually they have to be informed, as well as the family physician also. Of course, the condition is like this. There is no progress. Prognosis says that he will die definitely. So let us give the euthanasia. So please remember, previously the judicial magistrate of first class, he has to inform. But now the executive, the hospital authority also can hand over a copy of the advance medical directive issued by the notary to the family members or the family physician. Right? Executive, any authority, executive authority can do the same. And please remember, the informing the government. How to inform the government? Previously, the copy of the advance medical directive has to be sent to the local municipality or town or corporation like that. Presently, please remember, it can be made as a part of the advanced medical directive, or please remember, it can be made part of the digital health record also. So whenever this advanced medical directive is given, yes, definitely they can make an entry in the record. You may be knowing every medical activity is being digitalized. Suppose if there are thousands of hospitals, if you go to a hospital, your medical record will be digitally available. Whatever disease you got, they will also easily understand. Then preliminary opinion. Please remember, previously to allow euthanasia, normally 3 members board has to be exceeded, and now please remember only the treating physician plus 2 doctors of 5 years, previously it's 7 years experience, of 5 year experience, definitely they can be giving the opinion. And final opinion, please remember, collector will constitute another board with the DMNHO and 2 other doctors. So here the present direction is hospital can itself initiate the second board. And please remember, withdrawal of the treatment, previously collector has to inform the judge. Judge will authorize, but nowadays please remember, hospital can inform the relatives and withdrawal of the treatment can be started. And this is the easy way for method of execution of the euthanasia. So very important guidelines. Of course, those who are interested in this topic, they can only understand. Normally, for others, it is almost a 0 value. But anyway, very good guidelines. It may be of help to you in future. That's why I am making this video. With this, I am concluding. Thank you very much.